Hi, my name is Glen Goland. I'm the Senior Wealth Strategist here at Arnerich Massena. Thank you very much for taking the time to watch our video. Today, I'll be discussing one of the most important topics in financial and estate planning, and that is the 3 ways that property transfers at death. For over 20 years, I've been advising clients on financial and estate planning matters, and I find that this is one of the most commonly misunderstood and most important issues for families to have their arms around. One common way that property transfers at death, particularly real estate and bank accounts, is via joint ownership. If you consider the example of a married couple that owns their residence jointly, when the first spouse passes away, the surviving spouse needs to only file a death certificate with the county to take full possession of that property. It's important to note that in this situation, the words and provisions of that first spouse's will are completely irrelevant. The joint ownership is what will control the transfer of that property. A second way that property transfers when we die is via contract. Now, a lot of the clients that we work with are familiar with this type of transfer because they've filled out beneficiary forms for their retirement plans or for their life insurance policies. But there are some other contractual relationships that come into play here too. Anytime that you set up a trust and name a trust beneficiary, or anytime you add a transfer on death designation to a bank account, or in many states a piece of real property, then adding that designation, that contractual relationship, will cause those assets to pass outside of your will and instead under the terms of that specific contract. The final way that assets transfer when somebody dies is via the probate courts. Now, the probate court is where your will is administered. So any assets that you do not hold jointly or that do not have beneficiary designations attached to them will ultimately be administered under your last will. Now, states' rules around probate vary widely, but generally speaking, the process takes 6 to 12 months, can be expensive, and is very public. So for individuals that do not want to have a complete listing of their assets listed in the public record, it's often recommended that they take a look at setting up a trust during their lifetime to maintain that privacy. Each of the ways the property transfers at death carries with it its own set of rules and tax consequences. If you'd like to talk about how those rules and tax consequences may impact you and your family, we'd be happy to have that conversation. Please give us a call, or you can find our website at www.arnerichmassena.com. Thank you for watching our video.